Good afternoon, may I please the court, Your Honor. Attorney Damien Cash, P number 85852 on behalf of Mr. Taylor Byer, who is approaching the podium, Your Honor. Mr. Byer, state your name for the record.
Your name?
Taylor Byer.
Thank you, sir.
Um, what were you looking on doing with this?
A man drives 4 hours to stand before a judge, only to have his entire defense crumble in minutes. Today, we're breaking down the case of People versus Taylor Meyer, a defendant who tested positive for cocaine while on bond and claims he has absolutely no idea how it got into his system. His explanation? Maybe he touched something. Yes, you heard that right. He's suggesting cocaine somehow entered his bloodstream through casual contact. The judge is not buying it. With outpatient treatment supposedly in progress and a confirming test still unpaid for, Taylor's freedom hangs by a thread. Will his excuse hold up, or is he about to learn the hard way that the court doesn't play games? Let's get into it.
Your Honor, I know he's in person to discuss his recent test results, and at this time, I'm in receipt of the second part of the uh, pending plea offer. I'm just asking for a brief adjournment for me and Mr. Byer to further discuss this matter to potentially resolve at the next pre-trial hearing.
I'll start giving this to October 15, 2025, 9 a.m.
Would that be via Zoom, Your Honor?
You have his latest progress report?
I do have his latest progress report, Your Honor.
All right. What did you want to say about it? Because I'm trying to figure out, you want to explain the cocaine?
And here we go. The judge cuts straight through the legal formalities and gets right to the point. Explain the cocaine. See, this is what makes courtroom moments so compelling. The attorney is trying to smoothly request an adjournment. Keep things procedural, buy some time, but the judge isn't interested in delays. She's got a progress report in front of her showing cocaine in this man's system, and she wants answers now. This is the moment where Taylor Meyer has to face the music. His attorney can only do so much. The spotlight is directly on the defendant, and whatever comes out of his mouth next could determine whether he walks out of here or gets taken into custody. Pay close attention to what he says.
I've been doing everything.
Mr. Allen. Huh?
I've been doing everything I'm supposed to, and I do not know how that happened. I don't know if there was like a residue or something. I don't know.
You don't know if what?
I've done nothing there.
Well, you said, I don't know if there was what?
If there was like something I touched or something, so I know that can be something that can happen, but I've been
You get
doing
cocaine in your system? That does happen with amoebas.
Okay, let's pause right here because this is wild. Taylor Meyer is standing before a judge. Cocaine confirmed his system, and his defense is, wait for it, he might have touched something? He's essentially claiming that cocaine entered his bloodstream through incidental contact, like maybe he brushed against a surface or handled something contaminated. Now look, I'm not a scientist, but here's what we know. Cocaine doesn't just absorb through your skin in amounts significant enough to trigger a positive drug test from casual touching. That's not how drug testing works. The judge's response, that does happen with amoebas, is her basically calling out the absurdity of this claim. She's heard every excuse in the book, and this one is clearly not passing the smell test. What do you think? Is there any world where this explanation makes sense? Drop your thoughts in the comments.
You're saying this got into your system by you touching something?
I don't know. I don't know if it was a false positive. I don't know. But I've been doing everything to not do that. So
You have a medical marijuana card?
yes, Your Honor.
Did you ask for the test to be sent out?
Yeah, I'd like to get it.
Did you ask for it? When
Yeah,
you
I
found
did.
out.
Yes, I did.
Did you pay them for the confirming test?
I didn't pay it yet, but I told them I wanted to get it sent out. My community corrections.
When did you do that?
I just got back here from Traverse City Like I drove here 4 hours to get here.
Okay, but when did you tell them you wanted the confirming test?
I talked to Maya yesterday about it.
You talked to her yesterday?
Yes, I did.
And then when were you going to pay for it? What did she say?
She said that's fine and like told me I had to pay $30 and that's what I was going to go do.
Let me break down what's happening here for those unfamiliar with how drug testing works in the court system. When someone on bond tests positive for a substance, they have the right to request a confirmatory test, essentially a more detailed lab analysis to verify the initial result. This is important because rapid screening tests can occasionally produce false positives. But, and this is a big but, you have to actually request and pay for that confirming test in a timely manner. Taylor claims he only talked to his community corrections officer about it yesterday, and he still hasn't paid the $30 fee. The judge is clearly frustrated by this. If you truly believe you're innocent, if you genuinely think this was a false positive, why wouldn't you immediately pay that $30 and get the test sent out? The delay makes it look like he's stalling, or doesn't actually believe the confirmatory test will help him. This is Courtroom Strategy 101, and Taylor is failing it.
So he wants a hearing on this? Mr. Cash?
Your Honor, I believe we should have, you think between now and the 15th, a hearing, a follow-up hearing on the test results?
Well, I can set a hearing, but I don't know when when the confirmation test is going to be back because he's got to get $30 over there, but he's not going to be able to walk it over today.
But I'll leave it to the discretion of the court, but I agree. I think we should have one hearing between then.
But what I'll do is I'm going to adjourn it out to my next available date at this point, which is October 15, 2025. If you want to motion something up before then you can do it and motion it up. But I'll also set on that date the pretrial and a bond violation hearing.
Listen to what the judge just did there. She's not just scheduling a simple follow-up hearing. She's setting a PRE trial and a bond violation hearing for October 15th. That's legal speak for, we're taking this very seriously, and you need to be prepared to answer for this. The bond violation hearing means a court will formally examine whether Taylor violated the conditions of his release. If the confirming test comes back positive, or if he doesn't even bother to get it done, he's looking at serious consequences. His attorney can file a motion before then, but the clock is ticking. This is the moment where the weight of the situation should be sinking in for Taylor. But wait, what comes next is the real gut punch.
At this time, however, based upon these test results, defendant's bond is revoked, defendant's remanded. Yes, ma'am.
And Your Honor, just want to add, just for the record, he is now in outpatient treatment or attending outpatient treatment for substance abuse in Munson Hospital, at Munson Hospital in Traverse City. For the record.
Apparently, that's going well.
Boom. Bond revoked. Defendant remanded. That means Taylor Meyer is not walking out of this courtroom a free man. He's going into custody, effective immediately. And then, oh, the irony. His attorney tries to add that Taylor is currently in outpatient treatment for substance abuse at Munson Hospital in Traverse City. He's actively receiving help for his addiction. And yet here he is, testing positive for cocaine. The judge's response? Apparently that's going well. That is pure judicial sarcasm. Folks, she's essentially saying, you're telling me he's in treatment and he's still tested positive? That doesn't exactly inspire confidence, does it? This is a frustration that judges deal with constantly. Defendants who claim they're doing everything right while the evidence tells a completely different story. Taylor drove 4 hours to get here, thinking he could explain away the cocaine, and instead, he's leaving in handcuffs.
All right, thank you.
Thank you, Your Honor.
And just like that, the case of People versus Taylor Meyer comes to a swift and decisive conclusion. Let's recap what just happened. Taylor appeared in court to address his latest drug test results, which showed cocaine in his system. His defense? He claimed he might have touched something contaminated or that it was a false positive. The judge wasn't convinced, especially since Taylor hadn't even paid the $30 for a confirmatory test despite supposedly requesting one. To make matters worse, his attorney revealed that Taylor is currently enrolled in outpatient treatment for substance abuse, which only highlighted the contradiction. If he's getting help, why is cocaine still showing up? The judge's ruling was clear and immediate. Bond revoked. Defendant remanded into custody. Taylor will have to wait until October 15th, 2025, for his next hearing, a combined pre-trial and bond violation hearing, where he'll need to come with a much better explanation or face even more serious consequences. This case is a perfect example of why credibility matters in the courtroom. Excuses only work if they're believable, and claiming cocaine entered your system through touch is a hard sell for any judge. Actions speak louder than words, and Taylor's actions, delaying a confirmatory test, testing positive while in treatment, painted a picture that didn't match his claims of compliance. So what do you think? Was the judge too harsh, or did Taylor bring this on himself? Should he have been given more time to prove the false positive theory? Let us know in the comments below. We read every single one. If you found this case as eye-opening as we did, make sure to smash that like button, share this video with a friend who loves courtroom drama, and subscribe to the channel so you never miss another breakdown. Hit that notification bell so you're the first to know when we drop new content. Until next time, stay out of trouble, and we'll see you in the next video.